Hello friends, how are you? Namaskaram. Today I'm going to discuss an important topic concerning divorce which is usually filed by us against a wife. Our complaint is that the concerned wife is not ready and willing for restitution of conjugal right. She is not ready and willing for sexual intercourse. She is not serving my parents. And apart from that, she has subjected myself towards number of atrocity, cruelties, and that's why I am totally eligible for decree of divorce. The common story of Indian husband before the Indian courts. Friends, just think that by filing of divorce petition, can you get an appropriate remedy? Think before proceed. The answer will be negative because whenever you are going to file a divorce case, you have to engage a lawyer. You have to bear the fee. And fee may differ from lawyer to lawyer, depend upon the experience and expertise. And apart from that, it usually takes 2 or 3 years to conclude a divorce case. In the meanwhile, you cannot do a second marriage. The only option left with you is to have a sex with a concubine, or inter alia you may have a live-in relationship. Why are you going to spoil your own life? Why are you going to play with your medical issues? Do you know? Please remember and note down. Do you know? Not doing sex for a long time may subject yourself towards prostate infection, even prostate cancer, even prostate disorder. Just consult with your doctor. So, if you are having a wife and she is residing at her parental house for any cause, why are you getting afraid? Why you are not visiting the house of your wife just to have a sex with her? Ask her that I am here to have a sex with you. That is my right. If your right is to seek maintenance from me, then my right is to seek sex from you. Because whenever we are going to file a divorce petition, at the inception we are totally unplanned. Because filing of divorce petition may subject you with number of trouble. Number 1, engaging a lawyer. Number 2, preparation of case. Number 3, filing. Number 4, appearance opposite party. Number 5, contesting of case. Number 6, result. Number 7, appeal. Number 8, appeal. Number 9, appeal. Number 10, appeal. So, despite of that, we must be very much clear whether we have to file a divorce case or not. And whatever I am going to discuss in the present video is very much eye-opening. And apart from that, the same will inter alia provide you a path to proceed further. Are you ready? Ready now? So then note down. If we are going to plan for a divorce, then we have to follow the guidelines as propounded by Hon'ble Allahabad High Court in case of Pinky versus Pushpendra. The case number is 155/2011 and judgment has been pronounced on 6th of September 2024. In that case, inter alia decree of divorce had been granted to husband, and later on the said decree had been set aside by the Hon'ble High Court. The husband who had won the case had lost before the High Court just by a silly mistake. And this silly mistake usually done by us in the ordinary or routine course. Divorce is basically a negative word, which is not recognized under the Hindu law. Basically, it is usually termed as talaq in dictionary meaning, because it is the end of relationship, and that's why it is usually considered as negative in the Indian perspective. Got the point now? So whenever you are going to file a divorce, it means you are ready and willing to cease the sexual relationship. Think what will be happened after that. You would not be able to do sex with your wife because you are ready and willing to end the relationship. Are we a fool? No. Then why we are ending the relationship which was inter alia initiated by both the party by mutual consent? If wife is not ready and willing to reside with you, then she may go for divorce, but you should not file a divorce petition at the inception. The basic problem is that with our Indian husband, we are literate, we are educated, but we are not knowledgeable. We are not knowing the art of doing the family management. That's why the concerned Indian women are not going to be retained as wife with you, because it is basically a partnership in the term of marital institution wherein both party take vows in the name of God before holy fire that ये 7 जन्मों का रिश्ता है. But in fact, what we are going to do, just in few days or in few months or in few year of marriage, we used to file a divorce case on ground that bhai ab to nahi nibhega, then we have to file the case. Why? So this case which I'm going to discuss, in which the husband had filed a divorce case, mainly on the ground that he got frustrated by the concerned wife by her attitude, conduct, but not in term of cruelty, but in term of infertility issue. The marriage was solemnized. Soon after marriage, the wife is having infertility issue, and that's why he had filed a divorce case. The wife had appeared, and initially she accorded consent for divorce, and later on mediation had been taken place so that amicable solution can be done. But the husband, during the course of mediation, shown his willingness that he is ready and willing to revive the marriage, but later on he turned hostile. That is the foolish and silly mistake. Because once you had decided and determined that you are ready and willing for divorce, and internally have filed the divorce petition, then never took a U-turn that you may revive or you may reconsider or rethink on the survival of marriage. Once you take a U-turn or rethink for survival of marriage, in that scenario you could not get a divorce on the board. And that's why when he turned hostile, the wife submitted the second letter statement. The husband had opposed the approach of wife. He submitted that the wife is wrong, because on the one hand she is asking for divorce, on the other hand she is asking that divorce is not to be given. Apart from that, she submitted document that there is no infertility issue and the divorce has been brought on the wrong fact, and the procreation of child ipso facto evident that the said fact is false. And apart from that, there is no ground, whether in term of adultery or in term of cruelty, on the record, and that's why the consent wife requested the consent trial court to reject the divorce plea. But the consent trial court rejected the second statement of the wife by applying the principle of order 8 rule 9 of CPC, which inter alia bar the subsequent pleading. And apart from that, the court had inter alia gave strength to divorce plea of husband by relying on the admission of wife that divorce is to be given, that is available in the form of first written statement, and ultimately the divorce plea was allowed. The wife had challenged the said decree before the Hon'ble High Court. She submitted that the consent trial court acted in the arbitrary manner, because by the virtue of 3 points he convinced the court that the decision was wrong. Point number 1, the husband inter alia filed the divorce case, and at that time she was ready and willing for the divorce and accorded her consent by filing the written consent. Later on, when the husband shown his willingness, she has changed her decision and now she is not ready and willing for the divorce, and that's why subsequent pleading could be taken on record by the virtue of order 8 rule 9 of CPC, and the said view is retrieved by Honorable Supreme Court in judgment of Ashok Kumar Kalra. It's a recent judgment cited as 2020 volume 2 SCC page 394. And apart from that, it is also retrieved in the view of River Valley Tea Corporation Limited or Company Limited versus Assam Gas Company or Corporation Limited 2018 SCC online Guwahati page number 1168. And apart from that, in the matter of Kantipudi versus Putta Venkata, the Honorable Andhra Pradesh High Court retrieved the same view. So when the husband shown his willingness for revival, in that scenario he could not take the benefit of his own wrong. Number 2, taking U-turn amounts to condonation of the cruelty. And apart from that, all allegation asserted by the concerned husband is not supported by any documentary evidence, because there is no allegation of adultery, cruelty. Single allegation is of infertility, and which is also disproven by the concerned documentary fact on the record. So court observed that once consent is given, later it has been withdrawn, it is permissible. In that scenario, if the wife inter alia file the second written statement, it is permissible by the virtue of law. And apart from that, in ample judgment, the Honorable Supreme Court is of view that if during the pendency of mutual divorce petition, the concerned wife withdraw the consent, in that scenario, she could do so, and the divorce petition cannot be allowed on the strength of such withdrawal, merely on the ground that initially she accorded consent and later on she has withdrawn. Okay, now. So the said decision inter alia decided in favor of wife, wherein decree of divorce has been rejected due to the foolish mistake of the concerned husband. So whenever we are going to file a divorce case, just remember 5 points. Number 1, whether you are able to chase your wife or not. If you are able to chase, means can you do sex with your wife, can you chase her, can you contest her? If not, in that scenario, better remedy is that you should file a divorce case. Number 2, while filing a divorce case, never take any U-turn. Number 3, your pleading should be consistent and supported by documentary evidence. Do research work while filing the consent divorce case. And number 5, your petition should be appropriate and up to the mark. If they are not, in that scenario, you could not be succeeded. So remember all this point, fight your case and definitely we will win. Okay, now? So there is no need to worry, just we have to emphasize on certain points of equity, equilibrium and section 23 of Hindu Marriage Act to be succeeded in a divorce case. So see you in the next video. Till then, Jai Hind, Jai Bharat.